Welcome. Let's pick up on professional standards of care, part 2. We just finished the Osborne v. Irwin Memorial Blood Bank case, and I'm going to start my slideshow here, if I can get to it. And we are going to review last Friday's class, which was Professional Standards of Care Continued. Remember, last Wednesday, that would have been March 8th, Osborne Irwin Memorial Blood Bank was the case that was the first impression, the first reported case where an injured plaintiff, that's a party who contracted the AIDS virus, and in fact, it was a 3-week-old who had open heart surgery, who contracted AIDS from blood that was given by the Irwin Blood Bank. We walked through that case. That was the first case of professional standards. And there we learned that when it comes to professional negligence, not general negligence, but when it comes to professional negligence, the standard of care that is going to be the judge for the defendant, right? Where we're judging to determine whether or not the defendant actually violated the standard of care. That standard of care is based upon a reasonable professional who is similarly situated, that relies on the customs and the practices of other professions. That was the case. Is the standard of care one of a reasonable person, or is the standard of care one of a reasonable professional that's similarly situated? And we said, comes to professional negligence, that first element, standard of care, is based upon similarly situated, reasonable professionals, right? Excellent. Moving to the next phase. The next phase is a legal malpractice case, is Russo v. Griffin. And in that case, we know that we have to have a standard that is based upon reasonably situated professionals, right? So this isn't going to be a general reasonable person versus a professional person, right? Layperson versus professional. This is going to be a professional based upon local practitioners versus a professional based on statewide practices, or a standard based on statewide practices. Got it? I have two professionals. One professional is a group of professionals from a local area versus a group of professionals from a broader statewide area. Interested in your thoughts. As soon to be lawyers, right? You're just a hop, skipping, and jumping away. As soon to be lawyers, if your practice, if your standard of care has to be compared to other professionals, would you want that comparison to be based upon professionals in your area? For instance, if you're in Louisiana and you work in a certain parish, would you want your services to be compared to the services of someone in your parish? Or would you prefer your services to be compared to someone over the broad state of Louisiana? Or based upon the dissent in this case, in the Russo case, the Russo v. Griffin case, which we're about to go over, based on the dissent, would you want your practice to be compared to other attorneys on a national basis, right? Judge me by the folks in my parish, judge me by the acts of the other professionals in the state, or judge me by the other professionals based upon the nation. What would you prefer? Curious. And even more curious, why did you choose the one that you chose? Might be a question we pose in class for discussion. Interesting thought, right? Let's go with Russo v. Griffin. Procedural history. This is a lawsuit filed against an attorney. Trial court entered a judgment on behalf of the defendant attorney. The plaintiff appealed. So hold on. What we have here is we have a client who is the plaintiff who filed a malpractice suit against an attorney. Okay. Trial court entered judgment on behalf of the defendant attorney. The client plaintiff appeals. That's the procedure of history. What are the key facts? The plaintiff is actually a father who has a paving business, Russo paving business. The plaintiff wants to turn the business over to his sons, right? So now it's a family legacy business, but dad wants to step down and wants the sons now to take over. So the plaintiff and the two sons go to the defendant attorney and ask the attorney, can you do this transfer, do all the documents and things that we need? The attorney says, great. So the plaintiff goes to the defendant for legal services. The defendant attorney drafts a charter, files everything with the Secretary of State, does all the things that need to be done to transfer all the documents. Everything is done. I's are dotted, T's are crossed. All three parties are happy. Dad, two brothers, life is great. So what happens that the lawyer winds up getting sued? This is what happens. 3 years later, one of the brothers, this particular brother named Frank, wants out of the paving business, right? Right. I paving business has been great. I grew up in the paving business. I know the paving business. Dad gave half of the family paving business to me. I've done it for 3 years. It's been wonderful. It's been amazing, but I'm tired of doing paving. Want to do something different. In fact, the facts tell us that Frank is thinking about getting into the laundromat business. And so what happens? Dad, who used to own the business and turned it over to the two brothers, right? And the two brothers go back to the attorney who drafted the original documents and said, hey, Frank wants out. What do we need to do to get Frank his equity, get Frank whatever it is that he has coming to here from this business? Let's buy him out and let's leave the remaining son with the totality of the business. Attorney says, not a problem. Note to self, if this were a professional responsibility class, we would have a conversation about the potential conflict of interest. This is not a professional responsibility class, so that was just merely a note to self. So what the attorney is hearing is make sure that Frank is able to depart the paving business. Make sure that Frank is covered, that he gets his equity or his share, whatever it is he's supposed to get out of that business, so that Frank is able to go start this other business. So what the attorney is hearing is make sure that Frank is taken care of. All right. So in the process of all of the discussion, in the process of all of the meetings, in the process of creating and making sure all the documents are executed and signed, the attorney never tells dad and the remaining brother, or even Frank for that matter, one of the things that's often done when you have partners who are now separating from the business is a covenant not to compete. One of the documents that usually gets executed in this situation or similar situations is a covenant not to compete. Probably talked about it in property. What is a covenant not to compete? Is basically an agreement between two or more parties that somebody, one of the parties, is not going to come in direct competition with the other party. And years ago, most covenants not to compete had geographical requirements, geographical restrictions. For instance, let's say you're in a strip mall and you work for a nail spa, right? Nail facial day spa, right? And then you decided, I've been doing this, I'm an expert at it, I love it, people love me, I'm going to go out on my own. I've always wanted my own business, I'm out. Oftentimes, in order to get out, if you're an independent contractor or whatever it is, you might have a conversation with the owner of where you're currently working and say, hey, I'm going to go start my own business. And the owner says, well, hey, here's some goodwill. I am the reason that you got started. I am the reason that you were able to do this. I help support you. Will you agree not to compete with me? Right. And so basically what that would mean is you can open up your own day spa or nail shop, just don't do it in the same strip mall. Nowadays, you can go to a strip mall and see 5, 6, 10, 20 different nail shops, and you're wondering, right, are they all owned by the same people? So there really is no competition happening, or what's going on? That's an aside. In Russo v. Griffin, the attorney did not tell the parties about a covenant not to compete, didn't advise them, didn't give them any information on it, didn't explain it. So it wasn't done. You see where this is going? I know that you know where this is going because you've read the case, and we've already covered this case last Friday in class. But pretend you're listening, you're hearing, you're seeing this case for the first time. You know where this is going, don't you? Frank out of the paving business so that he could go into the laundromat business. Didn't stay in the laundromat business long. And in fact, got back into the paving business and now is in direct competition with the brother who stayed with Russo Paving. So now they're competing against each other. In fact, he was in the laundromat business for 3 months, and then he decided, nah, don't want to do it. What happens? Dad and remaining brother are hot. And they're probably hot, I'm guessing, because Frank is probably doing better. I don't know. I can only imagine what the family dinners or what the holidays are like with the two brothers competing directly against each other. And so dad and remaining brother, right, still known as Russo Paving, decide to sue the lawyer. Why? Because dad and remaining brother have probably talked to other lawyers and said, can you believe this? Is this legal? Can my kid do this? Can my brother do this to me? Can he go in direct competition with me? And probably had some other lawyers saying, yeah, he can. Didn't you execute a covenant not to compete? So that he couldn't, because if you didn't, then he can. And dad and remaining brother of Russo Paving probably said, what's covenant not to compete? We never heard of that. And then the new attorney said, well, didn't your old attorney tell you about it? The attorney who drafted up the documents, they didn't tell you about it? Ergo, lawsuit. Russo Paving Company now sues defendant attorney Griffin and Griffin and says that Griffin and Griffin committed malpractice because they failed to advise, suggest, recommend, or even explain this legal beast called a covenant not to compete. Clearly, they don't get it resolved because it winds up in court, and both sides have experts. A lay versus a professional expert, but both sides have experts. Russo Paving Company has experts that are well known in the state who do this kind of business, who have a good reputation in the state. And Russo's, that's the plaintiff, their experts are attorneys who come before the court and said, hey, standard practice, when you have partners dissolving a business, standard practice, if you're not representing one or the other and you're trying to represent them both, right? It is your duty, your responsibility, and the expected standard that you talk to them about a covenant not to compete. That's what we do statewide. That's what every attorney does that does this work. You can find any attorney in the state. They're going to tell you this is standard operating procedure. Okay. Plaintiff rests, defense puts on their case, and the defense puts on their case with their experts who are local attorneys, right? Have no reason to believe that they're not just as good. They're probably lovely attorneys, probably great reputation in the community, probably know exactly what it is that they're doing, right? So these are really smart, well-educated, well-intentioned, everybody's good. There's no good versus evil here. Local attorneys say, well, we know that that might be a statewide practice, but the way that we handle business, the way that the collective handle business, the way that the local cohort of attorneys that do this work handle this business, oftentimes don't have a conversation about a covenant not to compete. That's not our standard practice. That's not what we normally do. Okay. Plaintiff's attorney says it is standard practice to have the discussion about the covenant not to compete. Defense experts say it is not standard practice to have a conversation about a covenant not to compete. Based on the information that's provided to us in the case, there's no reason to believe that one side expert is better than the other side. They all seem to be equally qualified, equally received, equally respected. So what is a court to do? What is a court to do? I've got a battle of the experts, sort of. Both sides are qualified. Both sides are well known. Both sides have the skill, the knowledge, the education, the experience, the training. Well, what the trial court in Russo v. Griffin did was the trial court found for the defending attorney. Said, you know, this is what you do locally. This is what your experts said that you do locally. There's no reason to believe that your experts aren't credible or shouldn't be reliable. Defendant attorney, by not discussing the covenant not to compete, you didn't break any standard or expectation. I rule for the defendant, and the plaintiff didn't like it. Plaintiff didn't like it. The trial court ruled in favor of what is known in this case as the locality rule. The locality rule, right? If we're trying to figure out what the standard of practice should be, look at the customs and the practices of local professionals. That's the locality rule. What happened when the case was appealed? The locality rule was overturned. I know. The locality rule was overturned. So what does that mean? That means that the appeals court said, no, we disagree with the trial court. We believe that when the trial court accepted the locality rule, the trial court erred. Instead of looking at what the expectation is in the local area, What the court should have done was look at the expectations statewide. And so the appellate court, in their holding, reversed the locality rule, which was announced in the trial court, and remanded the case for a new trial with the direction that they're not to rely on the locality rule. Why did the appeals court reverse and, in essence, right, give the death knell to the locality rule? Here's the rationale of the reviewing court, which is the appeals court. The rationale of the court said, although attorneys throughout the state may be required to familiarize themselves with local practices, with local rules, or local customs peculiar to their area, the crucial inquiry for malpractice purposes turns not on the substance of the underlying practice or the local custom, but on whether a reasonable and prudent attorney can be expected to know of the existence of the practical application statewide. Because lawyers are licensed not by locality, not by community, not by parish, but because licensed or licensed statewide, then it just makes sense to the reviewing court that the standard by which attorneys within a state would be judged is going to be based upon the customs and practices of the accepted and the expected standard statewide. So that's the rule of law. Malpractice, standard of care, is based upon the standard that is announced and expected and utilized throughout the state, not the local jurisdiction, but the state jurisdiction. Again, if you read the Lexis case, you will see that there's a dissent in Russo, and the dissent says, well, if you're going to do it that way, if you're going to say, well, let's disregard what the local rules are, because you're going to assume that the local rules would never be adverse to the state rule. But if you're going to disregard the local practices and look instead at the state practices because the state licensed the attorneys, then why don't you just look at a national standard? Because all states follow directions of the American Bar Association that certifies all of the right. It's like, so why make it state? You know, why not just make it national? That's the end of the conversation. So I guess I would like to start, or I would like to end the discussion of Russo v. Griffin, where we started the discussion of Russo v. Griffin, and ask you, as a soon-to-be attorney, if someone is looking at your practice, how you execute your practice, how you execute the standards and the protocols of your profession, do you want to be judged by your local peers, the people that you go up against, the people that you work with, the people that you know, right, locally, or do you want to be judged statewide? And while Louisiana is a formidable state, what if you lived in a state like Texas or California, where at last count, right, you know, there's somewhere close to 200,000 licensed lawyers in the state of Texas, right? So food for thought, food for thought. It's important to know the rule of law, especially as a lawyer, because you will be in a position that if you feel like a rule of law is not supportive, but instead devastating or detrimental to a population, then you as an attorney not only have the opportunity, but you may even have a professional obligation or duty to do something about that rule of law. It's important to consider. Questions about Russo v. Griffin? Questions about Russo v. Griffin? No? Okay. Instead of going to Carbone v. Tierney, which is what we had planned to do for today, let's go through the connected quizzes questions. Some of the connected quizzing questions I was able to catch and get Aspen to correct. Some I were not able to get them to correct because they had explanations. If you are studying for me, you're trying to be best prepared for my final exam, the best advice that I can give you is pay attention to what we go over in class. While connected quizzing is a wonderful resource and a wonderful tool, I've seen enough of the questions that I've had to ask them to either correct or modify. And you have lots of classes with lots of responsibility and lots of your time is already taken. I really discourage you from just being out there in the world looking for questions to answer because some of them are just bad. So if you're wanting practice questions, I give you plenty of practice questions on the PowerPoints. Some we can go over in class. Some we don't go over in class, but they're on the PowerPoints. I've given you hypos for you to practice, for you to submit to me. I meet with you. We go through it together. If you're focused on what does Washington want, then pay attention to what we cover in class, right? Let's go ahead and go through these connected quizzing. I'll give you a little bit of an explanation because remember, this is just a review. We've already done this in class. And in fact, we did this on Zoom. This one's already posted because it was last Friday that room 227 was so hot that we had to do everything on Zoom. But let's just do a real quick review. Question 1, while on duty, but running a personal errand. While on duty, but running a personal errand over lunch, a military service person is involved in a car accident, causing damage to a civilian's car. The service person admits she caused the accident when she was distracted by a phone call. Will the civilian be able to recover from the military for the service person's actions? Read the question. While on duty, the service person ran an errand. The idea that the person is on duty inconsistent with the person being on a lunch break or a break. Here's the problem with the question. It's vague because it says while on duty, which makes me think there's no break, right? There's no frolic, right? But running a personal errand. And then the question says over lunch. So is it a lunch break or is it not a lunch break? I would not construct a question like that for you because as it's written, it's vague. But let's look at the potential answers we have. 1, no, the civilian will not be able to recover from the military because under the Westfall Act, he cannot sue her. He cannot sue her. No, the civilian would not recover from the military because the service person was on a frolic and could not be viewed as acting within the scope of her employment. Remember, frolics are breaks. What's the clue if you're looking at one of my tests and it's a frolic? You're going to be looking for the word break. It's an employee break or it is a lunch break. That's the word you're looking for, and you're going to know that that's a frolic, which means that respondent superior would not apply, right? You're reading for context. We're reading critically. C, yes, the civilian will be able to recover from the military because the service person was on a detour and could be viewed as acting within the scope of her employment. D, yes, because the Ferris doctrine applies. I don't know what the Ferris doctrine is. We have not covered it. So you know that the answer is not D, right? So what are the best possible answers? We know that it's not Westfall, right? We know that it's not Ferris. So it's either going to be B or C, where you're going to have to try to determine her being on duty, but running an errand during lunch. You're going to have to decide, is that a frolic or is that a break? What did Aspen say? Aspen said that was was that a frolic or was that a detour? Aspen said that that's a detour, right? This is one of the ones that I complained to Aspen because that very first sentence seems to create a impossibility, right? But they said that it was a detour, and the reason that it was a detour was because it was a personal errand and they were on duty. But over lunch, they really couldn't explain to me. Okay. Number 2. Todd and Aaron are involved in a biking accident which injures George. George sues both for negligence. The jury finds that Todd was 60% at fault, Aaron was 10% at fault, and George was 30% at fault. The total damages for George are $9,000. The jurisdiction uses a modified joint and several liability rule, which provided that all parties, including plaintiffs, share responsibility for bankrupt plaintiffs' portions of responsibility based upon each of the remaining parties' percentage of fault. Aaron is bankrupt. What is the most that George may recover from Todd? Here's the problem with the question. What Aspen meant to say was that the jurisdiction uses a modified joint and several liability rule, which provided that all parties, including plaintiffs, share responsibility for bankrupt defendants, right? We don't have a plaintiff that's bankrupt. That doesn't apply, but we do have a defendant that is bankrupt. All right. So let's read it as it should have been printed, which is the jurisdiction uses a modified joint and several liability rule, which provided that all parties, including plaintiffs, share responsibility for bankrupt plaintiffs or bankrupt defendants portion. So what is all of that mumbo jumbo saying? I've got 3 people. George, who's the plaintiff, who is himself 30% responsibility. I have Aaron, who's a defendant, who's 10% responsible. And I have Todd, who is a defendant, who is 60% responsible. Aaron, who's 10% responsible, is bankrupt. What is the most that George can recover from Todd? Here you go. When you have a modified jurisdiction that makes allowances for defendants who are on bankruptcy, what that modification means is the remaining parties take over the percent of the bankrupt person proportional to their share of fault. Okay. The defendant who is bankrupt, Aaron, who cannot pay because he's bankrupt, has a 10% stake in the fault, right? 10% of $9,000, just move the decimal, is $900, right? So we got to figure out who's going to take this over? Who's going to take this money, right? Who does that mean now that George is going to be 10% out because he can't recover it from Aaron, who's bankrupt? So what do we do? Because the call of the question tells us that the rule is the remaining parties share proportionately the percent that should have been due by the bankrupt defendant. That means that we're going to do a 6.66 split, right, to a 3.33 split. We're going to do a 2-to-1 split. Why are we doing a 2-to-1 split? Because George is, hold on, let's go back. George is 30%. Todd, wait, let's make sure. George sues both. The jury finds that Todd is 60% and George is 30%. So 60 to 30, that's a 2-to-1. You get it? And so now you're going to add that 6.6% to Todd's 60%, and you're going to add the 3.33% to George's 30%, and then you're just going to do the math, right? What's 66.7% of $9,000? 66.7% of $9,000. It is $6,003. $6,003. Well, I don't have an option that says $6,003, but I do have an option that says 6,000. So round down, that's the closest. If I've got a total of $9,000 and $6,000 is covered, what does that mean? That means that the remaining share is $3,000. Nikki, and actually what I just noticed is, and I don't, you know what, let me see. I think I can change it while I'm in, well, I can't, I think I can change it while I'm in the video. Nope, that's just gonna make me go, let's go here. I'm gonna change this because this should be Todd. Todd had 60%. And George had 30%. There, K-E-O-R-G. There we go. All right, so let's restart our slide. Start from the current slide. There we go. So because Todd had 60%, the most that he's going to be able to get from Todd is $6,000. Oh, back up. I'm not going to put that on the final, right? Because for some of us, in order to do that math, we need a calculator. And I don't want smartphones or smart watches or smart glasses or any of that stuff, so you wouldn't have access to a calculator. So that's not going to be on the exam. Question 3. Nikki and Karen are involved in an automobile accident which injures Seema. Seema sues both of them for negligence. The jury finds that Nikki was 80% at fault and Karen was 20% at fault, and that Seema's total damages are $100,000. The jurisdiction uses traditional joint and several liability rules. What is the most that Seema may recover from Karen? Answer is C, right? Traditional joint and several liability means that one can cover for all. So it's absolutely appropriate that Karen could be asked to pay the total $100,000. It's also absolutely appropriate that Nikki could be asked to pay the $100,000. right? Joint and several liability, one takes it for the team. Got it? All right. 4, many hunters are out on the first day of duck hunting season. It is very crowded, and hunter 1 is unlikely enough to be shot twice. Unlucky enough to be shot twice. First, hunter 1 is shot in the left arm by hunter 2, causing very serious injuries. And then hunter 1 is shot in the right leg by hunter 3, causing a minor flesh wound. Got it? The 3 hunters had never met before the shooting. Assume that both hunter 2 and hunter 3 were negligent in shooting hunter 1, and that hunter 1 was not negligent at all. Hunter 2, who shot hunter 1 in the left arm, causing huge injuries, left town and is nowhere to be found. If hunter 1 sues hunter 3 for negligence, she will be able to recover what? Will the injured hunter be able to recover for the arm injury that was caused by hunter 2? Thinking. Can hunter 1 recover for hunter's 3 leg injury? Thinking. Can hunter 1 recover for both the arm and the leg? Thinking. Leg injury, but only if hunter 2 was at least as much at fault as hunter 3. Thinking. Leg injury. Why? This is not an indivisible injury. indivisible. Indivisible. What does indivisible means? Means I cannot divide it. This is not an indivisible injury, right? That's joint and several liability. I have to have an indivisible injury, right? This is a divisible injury. divisible. It's divisible. It's divisible because I can divide it. I know that hunter 2 caused the injury in my arm. There's no question. I know that hunter 3 caused the injury in my leg. There's no question. If hunter 2 can't be found, well, looks like I'm not going to recover from my arm. I can definitely sue hunter 3 for my leg, but I can't ask hunter 3 to be responsible for my leg and my arm, right? Because hunter 3 had nothing to do with my arm. That makes sense? Right? Question 5. Farrah and Jackie are involved in an auto accident which injures Barry. The jury finds that Farrah was 70% at fault and Jackie was 30% at fault, and that Barry suffered $100,000 in damages. After Barry collects $40,000 from Jackie, Jackie sues Farrah seeking contribution or indemnity. In a jurisdiction applying the traditional rules of joint and several liability, how much may Jackie recover from Farrah? Let's slow down. Let's read it again. Farrah and Jackie are involved in an auto accident where Barry gets hurt. Farrah is 70%. Jackie is 30%. Total damages are $100,000. Jackie pays Barry $40,000, right? But how much was she supposed to pay him? She was only 30% at fault, right? You don't need a calculator for this math. So at most, she was supposed to pay only $30,000, right? But because we're joint and several, assuming an indivisible injury, that means that Jackie might wind up paying more than she's supposed to, yeah? And if you have co-defendants, indivisible injuries, joint and several liability, and one defendant pays more than their share, right? The defendant who pays more then their share is able to seek contribution from the other defendant or defendants, right? That's called the rule of contribution. Well, remember, we've talked about this. While Jackie has overpaid by $10,000, ideally, Jackie would be able to sue Farah to get Jackie her extra $10,000 she paid. But remember the rule. Jackie cannot do any of that until the plaintiff is made full. Plaintiff is made whole. Judgment has to be paid in full. So the fact that Barry's only gotten $40,000 out of $100,000 that he's owed means that Jackie cannot go after Farah for anything until Barry gets made whole. See, right? And that makes sense because if Jackie paid 40, Farah hadn't paid anything. Barry's owed 100, and so he's got 40,000 of it, right? He's still owed $60,000 between the two of them, right? Somebody, because it's joint and several. I don't care who pays me, but I need my other $60,000. If Farah's in a bind, and Farah says, "Well, I owe Barry 60. Actually, I owe Barry 70 because I'm 70% at fault, but I need to reimburse Farah the $10,000 that she overpaid." Which one do you think Farah's more likely to pay? She's more likely to pay the $10,000 debt instead of the $70,000 debt, which means Jackie is made whole, but Barry's still stuck. That's why the plaintiff has to be made whole. They have to be paid in full before any party can exercise the right of contribution. Number 6, an employee of a delivery service while delivering goods for the company. Say it one more time. An employee of a delivery service while delivering goods for the company negligently injures a woman. The woman sues the company for the negligent conduct of its employee. The company was not negligent in hiring or training the employee. The woman can prove her actual damages were $125,000, but the jury found that she was $20,000. She was 20% at fault. And so her ultimate award against the negligent employee is going to be $100,000. The company now sues the employee for $100,000. In a jurisdiction with traditional joint and several liability rules, what is the most likely amount the company will recover from the employee? Poorly written question again, right? It's just a poorly written question. Aspen is not saying that they assume that you're going to take into consideration. Aspen is assuming that when the woman sues the company for the negligent conduct of the employee, they are assuming that you're going to assume that the company actually paid the $100,000 judgment to the woman who was injured, right? And once the company paid the $100,000 to the plaintiff, and the plaintiff has now been made whole, the question is, if they want to sue the employee based upon indemnification, how much could they get? Of course, they could get $100,000. right? The company wasn't negligent. The employee was negligent. The employee was within the scope, right? Or acting incidentally to the scope because the employee was out delivering, doing the work of the business. Yeah. All right. And so the employer doesn't have any percentage of liability. All the 100%, well, it wasn't 100%. It was actually 80% because the woman who got injured was 20%. But the entire 80% fell on the employee, right? The company paid it, which came out to $100,000. And the company's like, we want our money back. Can they sue under indemnification to get their money back? Yes, they get all of it back, $100,000. Question 7. A technician at a hospital is a hospital employee complaining of early contractions. An emergency room doctor tells the technician to give the patient an ultrasound. The technician takes the patient alone into the ultrasound room, sexually assaults her. The patient sues the hospital based solely upon the technician's conduct. What is the result? 1, patient can recover from the hospital because the employers are always strictly liable. Always, we know is a problem. Strictly liable when it comes to negligence, we know is a problem, right? Okay. The patient cannot recover from the hospital because employers are never strictly liable. And let me just fix this typo since we're here. We're going to make this, come on, mouse. Okay, well then don't. We're going to fix that, make that there. And then now we're going to go back to the slideshow. B, the patient cannot recover from the hospital because employers are never strictly liable. Well, just from the reading, we know we've got a problem with that because we've got a never and we've got strict liability. So right now I'm down to C or D. The patient might not be able to recover from the hospital even though the technician was a hospital employee. The patient might not be able to recover from the hospital if the technician is in jail and unable to pay damages. We know that, right? We know that D has nothing to do with anything. All right, answer's got to be C. Answer's got to be C. You strike out A because it says always and strictly liable, which has nothing to do with negligence. It has nothing to do, nothing, not even in respondeat superior. I said it's analogous because an employer can't say, well, I told that fool not to do it, right? That doesn't get them off, right? But there is no strict liability when we're talking about respondeat superior. So we know A is not right because of the always and strict liability. We know that B is not right because of never of strict liability. And have we discussed any case where somebody's not going to be held liable because they're in jail? Right? Process of elimination, the answer's got to be C. 8. A pedestrian is walking across the street when she is struck by an automobile negligently driven by its driver. Her left leg and right arm are severely injured. As she lay in the street waiting for an ambulance, she's run over by a second driver who is also negligent. Her left leg is further injured by the second accident. The pedestrian sues both drivers as joint tortfeasors. The jurisdiction permits contribution between joint tortfeasors. The jury renders a special verdict which awards the pedestrian $100,000 compensatory damages for the injury to her leg, right? I've got 2 injuries to my leg, and I get $100,000 for that, right? Driver 1 hit my left leg, driver 2 hit my left leg, and I have $100,000 worth of damage to my left leg. And I have $20,000 for my arm. It was only driver one who hit my arm. Driver two has nothing to do with my arm. Yeah. What is the most likely outcome? Either driver can be required to pay $120,000. We know that's not right, right? Even if it's a joint and several liability jurisdiction, you can't make driver two pay for an injury that's not part of the indivisible injuries, right? The injury to the arm is all driver one. Driver two would never have anything to do with that. So we know it's not A. The second negligent driver can be required to pay no more than $100,000. Why? Poorly written question. We have to assume that the first injury to the left leg and the second injury to the left leg are indivisible, right? We have to assume that you can't tell what part of the injury resulted from driver one, what part of the injury resulted from driver two, thereby making them indivisible, right? If they are indivisible, and if we are in a joint and several liability jurisdiction, we can expect that both driver one and driver two can be held accountable for the $100,000 for the leg. If we are in a several liability jurisdiction, then we would have to apply the indivisible injury rule. But that's why the answer is B. A party guest who is allergic to peanuts has a severe allergic reaction at a catered reception when he consumes an hors d'oeuvre with traces of peanuts in it. The caterer was notified of the guest's allergy in advance, but the caterer was running late in preparing the food for the event and decided to take a chance with cross-contamination and did not wash utensils or cutting surfaces that had been in contact with to preparing the food. If the guest sues the caterer in intentional tort, he is likely to win A, B, C, D. Not answering question 9. We are not covering intentional torts. That was covered in torts 1. Because we are looking at what Washington is going to put on her exam, Washington is not going to put on her final exam intentional torts. Question 10. A delivery truck driver is tired in the middle of his shift from all of his driving. So he stops by a coffee shop to get a latte. While in the shop, the truck driver, in a hurry and not acting carefully, accidentally spills his hot coffee on another customer in the store, causing her serious burns. If the other customer, this is the other customer who the coffee was spilt on that was seriously injured, sues the truck driver's employer for her injuries arising out of the coffee spill, A, she may recover only if the trucking company was negligent in hiring. This is not a negligent hiring case. That exists. That's a real thing. That is not something that we covered. That is not something that I'm going to test. So we know it's not A. She may recover only if the truck driver was negligent while acting in the course and scope of employment with the trucking company. Okay, right. Respondeat superior. Okay. She may not recover because the truck driver, not the trucking company, injured her. Well, right, we know under respondeat superior, the company may be held responsible for the negligent acts of its employees if they are done within the course and scope of the business, or if they are done it just slipped me. If it's done in the course of the business, or if it's relevant to the course of their business, right? She may not recover if the truck driver was negligent. Let's read the question again. A delivery truck driver is tired in the middle of his shift from all of his driving. This is not a break. He's in the middle of his shift. So he stops by a coffee shop to get a latte. This is not a break. This is a detour. While in the shop, the truck driver, in a hurry and not acting carefully, accidentally spills his hot coffee on another customer in the store, causing her serious burns. If the customer who was injured sues the truck driver's employer for her injuries, right, she may recover only if the truck driver was negligent while acting in the course and the scope of his employment, which we would argue that he was, because he was on a detour to get coffee because he was tired. He was not on a frolic. This was not an employee break. This was not a lunch break. Okay? Gone through them in class. You have them to look at. You've got the connected quiz. You know how to reach me. If you have any other questions, remember, we started this conversation with the second case that talked about professional standards. That was the Russo v. Griffin case. We know that we have to have an expert witness. Here we have an expert witness that gives us the standard, but the standard is going to be based upon a state jurisdiction, not a local jurisdiction. Don't just say jurisdiction, because if you did that in your brief, there's no way that I can give you full points for that, because I don't know if you're speaking of a state jurisdiction or a local jurisdiction. As lawyers, the only superpower we have are our words and our heart. But our words, right? Life and death lives in the tongue. It's our words. So we have to be precise with them. We have to be clear with them. We cannot assume that a judge or a jury or even a professor knows what we're thinking in our head. All what you either say or that you put on the paper. Yeah. So make sure that you take every opportunity to be deliberate and to be precise. That's going to end this video. This one's been a lot of fun. I'm going to see if I can get through Carbone and Tyranny. I feel like I'm about to lose my voice a little bit. So Carbone and Tyranny, which is the third case for professional standards, might not be posted until tomorrow, but if I can push through, I'll go ahead and do that on the next video and get that one posted tonight as well. I thank you. I hope that by adding this to your toolboxes of resources, that this helps as you review, and it helps as you prepare, and it helps you understand, not to memorize, but it helps you understand the law, the process, and how it works. Because if you understand it, you can always think yourself through it. If you memorize it and you forget it, then you're just going to be stuck. If you have any questions, reach out to me. Text me, email me, call me. It's been my honor. I'll see you in the next round.